Interpretación. Adelante.
Yes. Hello, everybody. Good afternoon from Geneva and good morning to you. I don't know whether you see my presentation.
Sí, correcto. Hay que ponerla en modo de presentación. Okay. It's right. Okay.
Okay. Yes, hello. I'm Christine Bader from the ILO, the only tripartite UN organization with the mandate to achieve decent work for all. And I want to talk to you about decent work as an ally in the fight against IUU fishing. I will also try during my presentation to address some of the questions raised and maybe afterwards also. So IUU fishing, I don't want to duplicate what I want to emphasize. IUU fishing has three dimensions. Of course, the environmental dimension as a threat to sustainable oceans and to sustainable fisheries. And we all know that approximately 1/5 of all catches come from IUU. It also has a significant economic dimension. And as you know, almost 20% of the world's reported value of catches come from IUU fishing. And so the numbers say it all. And it is, of course, a perfect example of unfair competition. But IUU also has a social dimension, as was already mentioned. I'm speaking, of course, about the famous link between IUU and decent work, or rather the absence of decent work. So it has been indeed observed that severe labor violations and human rights abuses often coincide with IUU fishing practices. They occur concurrently often. So why are IUU fishing practices sometimes associated with human rights abuses? Well, it is quite logical when you come to think of it, because vessels engaged in IUU fishing tend to evade regulations in general. They hide from legal authorities. They elude monitoring and enforcement mechanisms. Vessels are sometimes at sea without rest for weeks, months, or even years at a time. And Alicia has addressed this with the aid of the transshipment practices. They often have on board vulnerable fishers that do not know their rights. For instance, undocumented or migrant fishers, and they were identified in an ILO tripartite meeting on issues related to migrant fishers as more likely to be forced or coerced into such illegal operations. And it has been observed that this in turn usually has a negative impact on wages, on working and living conditions of all fishers. This undermines vessel safety, promotes or exacerbates exploitative labor practices, lets human rights abuses go undetected, and may give rise or even facilitate forced labor and human trafficking. Now, as I mentioned forced labor, let me talk to you about the Forced Labor Convention, number 29, which is one of the 8 fundamental ILO conventions recognized as international human rights instruments. Convention 29 is part of the fundamental principles and rights at work, together with the abolition of child labor, the elimination of discrimination, and of course, freedom of association and collective bargaining. Member states of the ILO have committed to respect and promote these 4 fundamental principles and rights at work, whether or not they have ratified the relevant conventions by virtue of their membership in the ILO and adherence to the values of the ILO. And I'm pleased to say that Convention 29 has been ratified by all 10 member states present in this meeting. So Convention 29 is the first convention on the subject, defines forced or compulsory labor as all work or service which is exacted from any person under the menace of any penalty, and for which the said persons have not offered themselves voluntarily. It requires ratifying states to suppress all forms of forced or compulsory labor and to ensure that the use of forced labor is punishable as a penal offense and that penalties are adequate and strictly enforced. Now, at the time of Convention 29 in 1930, forced labor was primarily used by colonial administrations and in certain independent states, and much has changed since then. Today, the ILO estimates that about 21 million men, women, and children are in forced labor around the world, trafficked, held in debt bondage, or working in slavery-like conditions. 90% are exploited in the private economy, and almost half of all victims have migrated in some form, either across borders or internally. Forced labor generates an estimated $150 billion in illicit profits, causing industries and businesses to face unfair competition and states to lose billions in tax income and social security contributions. Now, that is why the tripartite International Labor Conference, composed of employers, workers, and governments, also sometimes called the World Parliament of Labor, has adopted in 2014 a protocol to Convention 29. And that protocol, in line with the convention, reiterates the importance of prosecuting the perpetrators of forced labor and ending their impunity. The protocol also reaffirms the definition of forced labor.
Oh, yes.
While emphasizing that it encompasses situations of trafficking in persons for the purposes of forced labor or compulsory labor. And also, more importantly, the new protocol puts the focus on two things: to prevent forced labor, firstly, and secondly, to protect victims and provide them with access to remedies. Now, 2 out of the 10 countries here present have ratified the protocol. That is Panama, which has ratified quite early. This protocol is already in force. And Costa Rica, which has ratified last year, and the entry into force will be in November this year. The ILO has also developed a set of 11 indicators covering the main possible elements of a forced labor situation, which provides the basis to assess whether or not a worker is a victim of this crime. So you have, as an indicator, the abuse of vulnerability, deception, restriction of movement, isolation, physical and sexual violence, intimidation and threats, retention of identity documents, withholding of wages, debt bondage, abusive working and living conditions, and excessive overtime. Now, the presence of a single indicator in a given situation may in some cases imply the existence of forced labor. However, in other cases, you may need to look for several indicators, which taken together point to a forced labor case. Now, let me turn to Convention 188. Convention 188 covers all aspects of the world of work of fishers. And I won't read through the whole list. Unfortunately, no country present here has ratified Convention 188 yet. We know of some countries that are taking steps. And this tripartite meeting I was talking about in relation to issues of migrant fishers has identified forced labor as a major problem in the fishing sector. And as such, Convention 188, of course, seeks to achieve decent working and living conditions in the fishing sector and already tackles one forced labor indicator, which is abusive working conditions, as we have seen. In particular, the following provisions of Convention 188 have also a preventive effect as they tackle the main factors contributing to forced labor, as also identified by this tripartite meeting. Firstly, you have the provisions relating to fair recruitment. They tackle really the abuse of vulnerability and deception. So these are two forced labor indicators there that are kind of enabling for a forced labor situation. And you have a provision, for instance, in 188, seeking to achieve that fishers should not pay for the job. So because the practice of recruitment fees or related costs being charged to migrant fishers leads to high debt burdens that can give rise to debt bondage and thus to forced labor. So C188 prohibits that such fees are borne directly or indirectly. So not even via deductions from remuneration or via reduced benefits. This is prohibited, that they are borne directly or indirectly in whole or in part by migrant fishers, be they already recruited or job seekers. And the term recruitment fees or related costs has been defined and includes any payments for recruitment services, be it direct recruitment or for a third party. It includes medical costs. It includes insurance costs, costs for skills and qualification tests, costs for training and orientation, equipment costs, travel and lodging costs in the recruitment process, including for return or repatriation, and administrative costs for fulfilling the recruitment process. Now, another provision of 188 prohibits the practice of blacklisting. Now, blacklisting is the operation and circulation by certain recruitment and placement agencies of lists enumerating names and details of migrant fishers not to be engaged. And this is usually done for reasons such as the filing of a complaint concerning wages or working conditions, or the exercise of the right to establish or join a trade union, or the exercise of legitimate trade union activities. So this is also prohibited. And then you have another provision. Most importantly, C188 requires that private services providing recruitment and placement for fishers are operated in conformity with a standardized system of licensing or certification or other form of regulation. So, because this ensures a regular review and evaluation of the recruitment process and the efficient control of their work, and allows taking measures to address abusive recruitment methods and practices, for example, through the suspension or withdrawal of the authorization to operate, but also through adequate fines or other penalties, and as well as, if need be, criminal investigation and criminal sanctions. Then you have also provisions in 188 like hours of rest to avoid long-term fatigue, which increases risk of injuries. That tackles another forced labor indicator, which we have seen is excessive overtime. Minimum age, no fisher should work under 16 on a fishing vessel. That again tackles the abuse of vulnerability as another forced labor indicator. You have provisions on work agreements to be signed by the fishing vessel owner, the representative, which are comprehensible to the fishers and set out the terms of their work, such as methods of payment and the right to repatriation. That again empowers fishers and tackles the abuse of vulnerability. And you have provisions on crew lists and safe manning. And they also have a preventive effect as regards forced labor, because of course, if all crew members are accounted for, this prevents as a mismatch between crew list and actual crew count at a port inspection, for instance, indicates a high risk, as does a lower ratio of actual crew size as compared to the manning requirements. Also, the enforcement provisions of C188 correspond to one of the main measures enumerated in the protocol to prevent forced labor, namely labor inspection. So you have first flag state inspections, the primary responsibility for ensuring compliance with national laws, regulations, and other measures implementing C188 lies of course, after the fishing vessel owner with the flag state. And the flag state must exercise its jurisdiction and control effectively over vessels that fly its flag, must establish an effective system for inspections, must issue a valid document for certain bigger vessels to certify that the vessel has been inspected for compliance with 188. The flag state guidelines, the publication that you see here, aim to assist flag states in this exercise. They contain guidance on coordination of inspection services, and that was raised by Felix and also in the chat. This is one of the main challenges, basically, of implementing 188, the coordination of national authorities, of all national authorities that have a say in implementing the convention. And then, of course, you have port state control, because while the primary responsibility for compliance rests with the flag state, under C188, ratifying countries may carry out port state inspections on foreign vessels visiting their ports, including vessels from countries that have not ratified the convention, to check that fishers have decent working conditions. And due to lack of effective jurisdiction and control by some flag states, port state control may be the only time when conditions of fishers are subject to inspection. And the port state control guidelines that you see here provide practical guidance for port state control officers. And Convention number 188 has already shown its teeth. There have been detentions of fishing vessels under Convention 188, for example, in South Africa, following complaints by the crew about working conditions. So provided that C188 is widely ratified, implemented, and enforced, it will establish a level playing field in the fishing sector for countries and fishing vessel owners committed to providing decent working and living conditions for fishers, and it will protect them from unfair competition on the part of substandard fishing vessels. So how to combat IUU? Of course, the PSMA agreement is the lethal weapon in this fight. And however, in the fight against IUU fishing, an important component of these activities is often missing from the considerations of policy and lawmakers. Labor is left out of the equation very often. And you have to recognize that IUU fishing is committed by fishers, and there's ample evidence to suggest that in many instances of industrial IUU fishing, the fishers themselves are the victims. And here I can come in on a question that was raised on for instance, fishers committing crimes such as drug trafficking, etc. Or in this context, IUU fishing. There is actually, I mean, the ILO has no mandate on drug trafficking, but there is a clear provision in the protocol to Convention 29, which requires ratifying states to take measures so that competent authorities are entitled not to prosecute or impose penalties on victims of forced labor for their involvement in unlawful activities, which they have been compelled to commit. So you have to distinguish between victims and perpetrators, and criminalizing the victims is not the way. So you see where I'm getting at. It is not enough to protect the fish. You also need to protect the fishers. And the widespread ratification and implementation of C188 will contribute to addressing IUU fishing, because ratifying states will strengthen the national legal frameworks and establish decent working and living conditions of fishers, such as provisions concerning crew list, written work agreements, fair and transparent recruitment practices, which will help prevent exploitative labor practices, including for migrant fishers, eliminate forced labor and human trafficking, and thus obstruct an enabling environment for IUU operations. And ratifying states will, for the purposes of enforcing the law, put in place a system of flag state inspections and eventually port state control, which will detect human rights abuses and exploitative labor practices such as forced labor and human trafficking, and in turn, again, help combat IUU fishing. So strengthened social control on board fishing vessels and an improved fisheries control system can thus become mutually reinforcing. And then I have this nice illustration of what mutually supportive means. 4 pillars of the temple of quality fishing operations or sustainable fishing to illustrate the interrelatedness of the main instruments of FAO, IMO, and ILO that compose the international legal framework in the fishing sector. The CTA, the STCWF, PSMA, and C188. And as already explained, they are interrelated. Decent work can be an ally in the fight against IUU fishing. And vice versa, the fight against IUU can reduce the risk of human rights and labor abuses in the sector. Some states implementing the PSMA see the link between IUU and decent work deficits and would like to inspect working conditions on foreign flagged IUU fishing vessels. But they need a legal basis for that. And that is through ratifying C188. Then, of course, there is no decent work without safety. And decent work deficits may entail safety risks. Moreover, the entry into force of the CTA would give port state control of fishing vessels a regional dimension, amplifying and systemizing port state control inspections in fishing around the world, which would eventually be more effective than port state control carried out by individual states, because it would be more difficult to avoid. So joining forces, of course, makes sense, and we are joining forces, as also mentioned by Alicia, as illustrated by the joint ad hoc working group on IUU fishing and related matters, initially formed by the FAO and the IMO, and recently joined by the ILO, and which seeks to combat IUU and promote safety and decent work. Thank you very much. And I would like also to, probably before Felix, I don't know, I wanted to go back to some questions that were raised, but tell me if I can do so. Thank you.
Claro que sí, Cristín. Muchas gracias, Cristín. Claro que sí, con mucho gusto puedes aportar también a las preguntas que se hicieron. Para ti tengo un par de preguntas acá ya, pero adelante.
Yes. So I'm trying to, so there was these questions relating to artisanal fishing, and we are, of course, talking mainly here about industrial IUU fishing. And of course, IUU fishing has a big impact on artisanal fishers and threatens their livelihoods. They need to go, for us, we also see, you know, that they need, because the fish stocks are diminishing, they need to go further out, longer time out with their fishing vessels, which entails bigger occupational safety and health risks. And I think there was this question about fishery management rules imposed on artisanal fishers. And of course, the scale of IUU fishing in artisanal fishing is not, is very small. But artisanal fishers are sometimes just not, in some countries, they are just not able to comply with fishery management rules because it threatens their simple existence. The fish stocks are already diminished, and they have to obey rules that impact even more on their livelihoods, right? So here, what might be a help here in Convention 188, which also covers artisanal fishers, there's also a lot of emphasis placed on social security, which is of course a big challenge, right, for artisanal fishing, and a big challenge to tackle for states inter alia. And there was another question, because there's a lot of informality in artisanal fishing, and of course informality is not the same as IUU fishing, because otherwise you would have it's not illegal, yeah, otherwise you would have a big portion of the world's population being labeled as illegal. Informality is a big informality is a big challenge for many states to tackle, and there are many strategies that are being proposed by the ILO, and I won't go into these details, but of course organizing is one of the strategies, as Felix I think has mentioned. Organizing, whether in groupings, in cooperatives or trade unions, is a first step towards getting out of informality, towards formalization. And social security is also one of the strategies to come into formalization, because informality means basically you are not in the system and you are not on the radar of governments to provide help to you. These workers are invisible, basically. So that is the challenge. And I think there was another question of who informs ILO of labor violations. I've seen, if my Spanish knowledge is correct, there was a question in the chat in this regard. So the ILO has a supervisory mechanism, a well-established supervisory mechanism for states that have ratified a convention, and this mechanism supervises the application of ratified conventions. There's a regular way to get information. That means reporting, regular reporting by governments. And the reports are supplemented, or may be supplemented, by workers' organizations and employers' organizations of the country concerned. And having information from the three sources gives the ILO normally a very accurate picture of the situation on the ground. Now you also have an ad hoc supervisory mechanism that only is launched when there's a complaint. And complaints are also, can be filed also by national workers' organizations and employers' organizations of a ratifying country. So I won't go into more detail because it's quite technical, but I hope I have answered a few questions that have been raised.
Bueno, Cristín, muchas gracias. Aquí teníamos una pregunta que creo que ya respondiste, que era la tenía de Dulce, decía, ¿qué institución o organización pone en conocimiento a la OIT sobre violación de derechos laborales?
Yeah, I think I have answered where the ILO gets its information. Yeah, its information from on labor violations. Yes.
Record.
It's tripartite structure actually that allows the ILO to see what happens on the ground and what violations are occurring. Because workers and employers organizations, so workers and employers have an equal voice and vote at the ILO together with governments. So if you take all these sources of information, the ILO gets a clear picture of what is happening.
Gracias, Cristín. En esta sección no tenemos preguntas directas, abrimos el compás porque teníamos un tiempo. Por favor, si van a hacer preguntas directas, vamos a abrirle, pero para preguntas directas, no para comentarios. Comentarios vamos a tenerlo en la sesión posterior a la siguiente presentación. Así que vamos a darle la palabra a 1 minuto a Armando. Armando ya se fue. Bueno, a 1 minuto a la diócesis de Choluteca para una pregunta.
Sí, buenos días, soy el padre Mario de la diócesis de Choluteca. Mi pregunta sería, decía la licenciada Cristina, qué importante es cuando se está organizado y para que la pesca no sea, digamos, la que es de subsistencia, que pueda haber una veda, pero si fuera lo posible de haber una veda de pesca, ¿cómo ayudar al pescador en ese tiempo que él no va a pescar? Porque sí es importante tener un control sobre la pesca. De hecho, en el sur del país hay muchas especies que ya se están perdiendo, en el Golfo de Fonseca, donde yo estoy ahí desde hace ya 8 meses. Entonces la pregunta sería, ¿cómo ayudar a los pescadores si hubiese una veda a un tiempo corto plazo o largo plazo? No sé si se escuchó la pregunta.
Están traduciendo.
I'm not sure I understand the question, actually. I think, well, yes, I'm not sure I understand the question, but I have talked about organizing. I mean, organizing has a lot of value in many aspects. So organizing, be it in small groupings or in cooperatives or in trade unions, empowers fishers, right? Empowers them, gives them a voice, helps them to better reap the benefits of their work, because together they are stronger. On the other hand, also organizing can be a first step towards formalization, towards more visibility by the government, and which will in turn probably help the government to be able to take measures to help them to improve their working conditions or address their concerns in terms of declining fish stocks and threatened livelihoods, etc. So, of course, for us, for the ILO, organizing is fundamental, right? So yes, I don't know whether it has answered your questions. I didn't quite understand. Did that answer your question? Sorry.
Sí, excelente.
Okay.
Exacto.
Okay.
Sí, muchas gracias.
Ok, vamos a despedir a Cristina. Muchas gracias por tu presentación, muy interesante, muy objetiva y clara y que nos brinda.